Sofia had a green card within reach. Her husband was a U.S. citizen and had started the paperwork. But what he held over her every single day was a threat. If she ever left him, he would call immigration. He told her she had no status without him. He told her she had no options. Well, he was wrong. The VAWA self-petition is a legal process that allows abused spouses of U.S. citizens and permanent residents to apply for immigration status on their own, without their abuser's knowledge, without their abuser's consent. I'm immigration attorney Magdalena Cuprys. If you or someone you know is in a situation like Sofia's, this video is for you. What Sofia's husband told her is one of the most common forms of immigration abuse. Abusers who are U.S. citizens or green card holders often weaponize immigration status against their partners. I will get you deported. You have no rights here without me. If you leave, you lose everything. Well, that is a lie, and the law was specifically written to counter it. The Violence Against Women Act, known as VAWA, created a legal pathway for abused spouses, children, and parents of U.S. citizens and lawful permanent residents to petition for their own immigration status on their own without the abuser's involvement, without their knowledge, without their consent. Let me explain how it works. Who can file a VAWA self-petition? You may qualify a VAWA self-petition if you are or were the spouse or child of a U.S. citizen or the spouse or child of a lawful permanent resident. You must have suffered battery or extreme cruelty. Battery means physical abuse, but extreme cruelty is a much broader standard. It includes emotional abuse, psychological manipulation, isolation, threats, humiliation, financial control, and yes, using immigration status as a weapon against you. You do not need bruises to qualify. You do not need a hospital record. The abuse is real even when it leaves no visible marks. You must have lived with the abusive person at some point during the marriage or the relationship. And you must demonstrate good moral character, which in most cases simply means you have not committed serious crimes. The most important part, confidentiality. This is the piece that changes everything for survivors. USCIS, the immigration agency, is legally prohibited from disclosing information about your VAWA self-petition to your abuser. The abuser does not get notified. They do not find out that you filed. They cannot respond to your case or contest it. Your safety is built into the structure of the law itself. VAWA self-petitions are not processed at regular USCIS offices. They go to a specially designed team at the Vermont Service Center, specifically to protect the privacy and safety of survivors. If your abuser contacts USCIS to ask about your status or your petition, USCIS will not confirm or deny that anything was filed. What happens after you file? When you submit your VAWA self-petition, USCIS reviews your case. If they determine you have provided sufficient initial evidence, they will issue what is called a prima facie determination. That is essentially a letter stating your case appears to have merit. That letter can help you access certain public benefits and protections while your full case is pending. Once the self-petition itself is approved, the next steps depend on your specific situation. If your abuser is a U.S. citizen and you have been married for at least 2 years, you may be eligible to move forwards towards a green card. The process for spouses of permanent residents is slightly different and involves waiting for a visa number to become available in the queue. This path is not always fast. Immigration never is, but it exists. And it exists specifically because Congress decided that survivors of abuse deserve a way out that does not depend on the person who hurt them. So what evidence do you need? This is one of the first questions I get from every survivor considering this process. The honest answer is you probably have more than you think. You do not need a police report. Although one can help, many survivors never call the police. You do not need to have gone to an emergency room. You do not need a protective order. Evidence in VAWA cases includes things like a personal statement written in your own words describing the abuse and its impact. Statements from friends, family members, religious leaders, counselors, or advocates who witnessed the abuse or saw its effects on you. Medical records if you saw any treatment. Photographs of injuries. Text messages or emails that document threatening or controlling behavior. Records of calls to domestic violence hotlines. Evidence of your shared life with the abuser. Joint accounts, shared addresses, children's documents. Your own honest, detailed account of what happened is often the most powerful piece of evidence in the entire case. What if you are undocumented? VAWA protections apply regardless of your immigration status. You do not need to already have a visa or legal status to file a self-petition. Many of the people who file VAWA self-petitions are undocumented at the time they file. That does not disqualify you. What it may affect is the path to a green card, which is a separate step from the self-petition. An immigration attorney can walk you through what that looks like given your specific history. And what about your children? If your children have also experienced abuse or witnessed abuse, they may be included in your self-petition as derivative beneficiaries. Children of qualifying VAWA petitioners can be protected in the same filing. Their safety matters too. You are not trapped. No one should have to choose between their safety and their immigration status. The law says so. Congress created this pathway because it recognized how often abusers use immigration as a trap, and it built a way out that the abuser cannot control or destroy. What your abuser told you, that you have no options without them, that you will be deported if you leave, that you are powerless, none of that is true. You have a legal path. Your abuser cannot touch it, and you do not have to walk at it alone. If you or someone you know is in an abusive relationship where immigration status is being used as a weapon, please talk to an immigration attorney who handles VAWA cases. These options exist specifically to protect you, and your abuser cannot find out you pursued them. My firm, Serving Immigrants, helps survivors across Florida and Puerto Rico. If this video helped you or gave you something to think about, share it with someone who needs it. Subscribe and drop a comment. What questions do you have about VAWA?